Okay, assalamu alaikum. I hope this would be the last lecture in bankruptcy. And next week we have to finalize all what we have and we can speak about the exam. But for now, we have 10 slides to finish, or 11 slides in bankruptcy. We're still talking about bankruptcy in the UK. We finished with bankruptcy in the USA and the general meaning and concept of bankruptcy. But today, bankruptcy in the USA, we said, in the UK, we said that it's optional. Anyone can apply for bankruptcy, in which if he or she feeling that they cannot pay their debts, then they can apply for bankruptcy. One of the questions can be asked here, it's when and how. We did speak last time about when we can apply for bankruptcy, in which if somebody was in debt, there's some money were due to be paid and this person cannot pay them. Now, we said as well we have to submit the petition, which is called bankruptcy petition. But this bankruptcy petition have to be sent to the court. If the case in the UK, we can send the bankruptcy petition or the bankruptcy file, it has to be sent to the special court, which can be the High Court in London, and it can be the county court. In Palestine, we have the same situation. We have to send the bankruptcy petition to the appropriate court. It can be in Gaza City, it can be in Nablus, it can be somewhere else. This is based on the place of the debtor, where he used to live. If he was living in Gaza City, then we have to submit the file to the Gaza City court. If he was living in London, we have to send it to the High Court of London or County Court near the place he used to live. Location, we look, because we're not going to look at the place where the creditors live. We look at the place where the debtor lives. Location, the house where he normally lives. If he was not in the country, and sometimes happens that some people, they have their own business, and then at the time of bankruptcy they escape, they leave the country. Then if he does not exist in the country, if he's not living here anymore, then we have to look in the past, the last place he used to live in. If he was living in Gaza City, then we have to send the post to inform him of the date, the bankruptcy procedures to be taken place at the court. We have to send that document to the place he used to live in. Or we can send it we can send it to the place where he used to have his own business connection, where he used to have. I mean, if you want to have something like this, applying for bankruptcy, and you would understand exactly what you need to do, how you're going to make it, and which court you would have to send the application form, then there are some websites, there are some lawyers who would advise you on such situations. And anyway, there's a website here that's in the UK only. And this website you can look, you can find exactly how you can submit the application form or bankruptcy petition to the specific court. And after we submit the application form, which is called the bankruptcy petition or the bankruptcy file, then the court would decide if this application or this petition can be looked at by this court or not. If this court is the appropriate one, if this court had the jurisdiction to hear the bankruptcy case or not. If not, then this file would be sent to the specific court. If the court in Gaza City discovered that the debtor was living in Khan Yunis, then the whole file would be sent to the Khan Yunis court. So we look at the jurisdiction of the court, if it has the ability to look in the bankruptcy file or not. Then the next step now, we have to see what would happen at the court. If the court decide that its own jurisdiction, its own area, and it can look at this application, then in the court we will see now what would happen. What do you think can happen in the court? Imagine that today we have file of bankruptcy petition, and this file we send it to the court, and it was in Gaza City, and it was against Haneen. She was the person we wanted to be bankrupted. case against you, bankruptcy petition against you. Then, at this court in the Gaza City here, we have one of four possible solutions. The judge in the court can take one of four solutions. One of four decisions can be taken. If it was you, what can you do? Today you have a case like this in front of you, which is called bankruptcy petition, and you have to look at it. What can you do? Can you take a decision from the first session? Can you announce bankruptcy? Can you have a bankruptcy order, or a bankruptcy order, which is the decision which is made by the judge? And this decision means this person, the debtor, becomes a bankrupt muflis. He becomes a bankrupt on this date. Bankruptcy order was made. Bankruptcy decision, judgment was made. What do you think? If it was you as a judge, how can you look at this? Are you going to take the final decision on the same day, straight away? Oh, this person would be bankrupted, or you're going to give time to think about it? What do you think? Chance for what?
Reconsidering the whole case for more research and more inspecting of the whole case.
We see, if you look in Gaza, for example, here we have the courts. Most likely they would delay the files. And if you look there now, you find sometimes the judge having more than 20 files. He will look at them in one day. He might take decision in one or two files, but the rest of them he would delay to the next session. Next session can take few weeks, sometimes can take 1 or 2 months. Anyway, most likely a judge can delay the proceedings. Why should a judge delay the proceedings?
Because the court further need more information before it can make an order and make a decision about the bankruptcy.
Yes, exactly. Most likely we need more information, because the application was submitted by the debtor as voluntary bankruptcy. A petition was submitted by debtor. This petition does not include all the necessary information. We need some bank statements. We need to know exactly what happened to the amount of money which was mentioned in page 2, for example. We need to know all details. We need to get some witnesses. We can take some statements. So what we can do, we can delay 2 weeks, 4 weeks. It depends on the situation, and it depends how much work the judge can delay the case for a few days or for a few weeks. The next time we get more information, we can take decisions. So one of the possibilities, it's going to be delaying the proceedings. And this is quite often. Most likely you're going to have such a step is taken. Second point, second possibility, the judge can take, can dismiss. What does it mean, dismiss? Refuse. Yeah. Dismiss what? The whole petition. We say this petition we have submitted. لائحة الاتهام ولائحة الدعوة. This petition is dismissed. We cannot see it anymore. We cannot look at it because this is not appropriate. We can dismiss the petition perhaps, maybe because administration order would be more appropriate. I know that you will not understand such point if you don't attend the class. There is something called administration order. This we have to take it after a few slides. One of the alternatives for bankruptcy is called administration order. If the amount of money in debt were less than £5,000, then there is no bankruptcy. Take it into consideration. If the amount of money was less than £5,000 all the time, no bankruptcy. We can have administration order. There is no bankruptcy. Then the debtor would pay payments to the court until he finished all the payments. Because, £5,000, it's not an amount of money, it's nothing. £5,000 is about $8,000. It's nothing. When it comes to business, someone was in debt for $8,000 to be a bankrupt. It's not fair. So we can give that person more chance, more time to pay back. And this can be one of the reasons. Sometimes the whole case, the whole petition can be dismissed because leave it away, not looking at it, because maybe there was no reason to have bankruptcy. Maybe because the debtor can prove that he can pay the money for any reason. It's up to the judge. He can decide, because he has the discretion to decide if we can take a decision like this or not. If we can take a decision of bankruptcy, or we can dismiss the whole petition. Dismiss يعني إلغاء أو نترك القضية، ترك القضية خالص. Third possibility is IVA. You're not a student? Okay. Third possibility, which is called IVA. We had it last time. IVA, it's individual voluntary arrangement. In this case, the judge can appoint, he's not the judge, he can suggest that somebody which is called insolvency practitioner, which we're going to look at next slide to see. He is the trustee, which is something important we have to keep in our mind, the trustee. Just remind me after we finish here recording, I'm going to talk about the exam just for 2 minutes, which I'm going to explain. Sometimes you're going to have questions asking you to differentiate between two things. What does it mean? Like, for example, involuntary and voluntary bankruptcy. Implied in fact, implied in law. Things like this would be in the exam. What the difference between them. Just remind me once we finish, I'm going to talk about that. Now, the third possibility, the judge can suggest that individual voluntary arrangement, IVA, is a better solution, is a best solution for such case, because we have some reason to believe that this debtor can pay the money back, but he would need more time, as we did explain last time. In this case, we can appoint a trustee. In this case, the trustee is called insolvency practitioner. He can be a lawyer, he can be an accountant, or anyone else. This person with the debtor would make a plan, proposal, and submit all documents needed. Financial statements, bank statements, the debts, the amount of money we have, the machines, everything we have to be stated in a piece of paper and submitted to the creditors. If they accept such a plan, as we have to explain it in more details after 2-3 slides, if they accept such a plan, then we're going to have IVA. And then we have to send it to the court to authorize it. And it's not bankruptcy. So number 1, 2, 3, no bankruptcy decision can be made. No, because the last choice, the last chance is to make bankruptcy order. We have to keep it till the last. We have to use all options at the beginning, because bankruptcy order, it means the end of the life, the end of business life. Then we will not be able to come back to business easily in the future. Last option for the judge is bankruptcy order, bankruptcy decision, judgment. This is the final decision can be made by the court. If the judge can make sure that all documents are available, and he can make sure that debtor cannot pay debts, and he can make sure that it's not possible to have IVA, and it's not possible there's going to be administration order, then in this case bankruptcy order would be made. There's something here you have to keep in mind, which is called certificate of summary administration. Such certificates can be issued by the court. If the amount of money was not high, the amount of money was less than £20,000. I mean, in bankruptcy, people sometimes can be in debt millions of pounds, hundreds of thousands of pounds. Sometimes can be as little as £20,000, which is not much money. £20,000, it's not the amount of money we can consider. In this situation here, the amount of money was low, or lower than £20,000, and for the past 5 years, here, the bankrupt, who is the debtor, was not made bankrupted, and he was not made. He did not apply for IVA. In this case, we give him a certificate. This certificate would help to accelerate the process. This certificate would help the trustee, official receiver would then be the debtor trustee. But we can accelerate the whole process in which we can, instead of having discharge after 3 or 4 or 5 years, we can have it in 2 years. We can have it in 3 years. A discharge. I'm going to explain it now how it can be. Now, once we have a bankruptcy order, which let's say that was in 2001, in most places, and even in the UK, they said, if you have a bankruptcy the first time in your life, the first time, and most likely the amount of money was low, little amount of money, then you can be discharged after 12 months, which is going to be here in 2002. From the date you have bankruptcy order, you become a bankrupt, isn't it? Yes. Debtor become a bankrupt from the date of bankruptcy order. But then to have a discharge meaning freedom, relief. No one can ask you for nothing. Within this time, this can be sometimes 1 year, it can be 2, it can be 3, it can be 5 years, it can be even more. This is based on the whole situation. If maybe the amount of money was millions of pounds, if this is the second or the third time this company having bankruptcy, if this person was cheating, I mean, there are many reasons for the judge to use and to make his own decision. Now, the least amount of time can be a 12 month, 1 year, in which I can be, if I was bankrupt, after 1 year, I can go to court to have a discharge affair. Now, thing is, I want you to understand, within this period of time here, this can be 1 year, 2, 3, 4, whatever. Within this time, any money you make, you have to pay it back to the trustee. And he would take it, collect it, and divide it between creditors. Now, at the time of bankruptcy order, everything the debtor owned would be taken away from him, and the money, the cash and the assets would be divided between creditors. That's which is called the non-exempted assets. Now, within the time after the bankruptcy order, until we have discharge, any extra money the bankrupt make, you might get something like we will look at this in the next few slides. Any extra money he makes, it will be taken away from him and will be given to the trustee, as long as the extra money, which is called non-exempted. If it was exempted, you're not going to pay it. We know the difference between exempted and non-exempted. Do you? We have exempted and non-exempted assets. Anyone can explain the difference between them? Somewhere.
The exempted asset is the asset that remains with the owner, the debtor, and the non-exempted asset is what divided for the creditors.
Okay. Now, if you have non-exempted assets up to the time you have a discharge, any extra money you make will be handed to the trustee. But then once you have a discharge, relief, freedom, fresh start, new life, then after this date, any money you make, it's yours. You can keep it. Even if you become a multi-millionaire, that's yours. You can keep it. Now, as you can see that we have 2 types of trustees. Trustees are 2. And this can be a question. The difference between 2. Trustees, number 1 is called official receiver, and the second called insolvency practitioner. اللي هو المؤتمن الشخص الحارس القضائي. The trustee can be official receiver. Let's say look at the difference between them. Number 1, the official receiver is someone who works for the Ministry of Justice. He is a public employee. Meanwhile, insolvency practitioner is an independent person. He can be an accountant, he can be a lawyer, he can be an independent person. He can have his own office. He does not work for the government. Independent, like a lawyer. That's number 1. Number two, the duties here. Look at the duties. This can be appointed, official receiver can be appointed by whom? By the court. The court. But this insolvency practitioner is appointed by the debtor. Is appointed by the court and is appointed by the debtor. In addition to this, what they would do, what do you think? Official receiver, his duty is to collect the money, to collect the assets, which is called the bankruptcy estate. We have it before. It's something called bankruptcy estate. The whole amount of money, the cash and the properties of the debtor, the official receiver would collect them, and he would be the trustee, someone who is trusted on the amount of money. He would look at everything, and he would make the auction in which he can sell the assets and take the cash and divide it between creditors. But insolvency practitioner is not. He does not do the same thing. Solvency practitioner, he makes the plan, the proposal, with the assistance of the debtor. Both of them, insolvency practitioner with the debtor, they make the plan, and this plan includes the amount of money he has, the amount of money he can pay, and how long time will it take the debtor to pay back, which is called repay, to pay the money back to the creditors. But this cannot be in due, like cannot be on time like it was before. Now we have to give the debtor a new date, extra time. We have to extend the time. Like if the amount of money I was due to pay today was £100,000, I don't have that amount of money, then we can set a new date. We can have a new date which can be like 2 years time, 3 years time.
It differs from reorganization.
No, this of course, yeah, that's a good point. I mean, this is in liquidation. Official receiver can be only in liquidation, and insolvency practitioner can be in reorganization. That's number 4. There's a difference number 4 between them. Okay? Is easy? Fine? It's not difficult. So we have 4 differences. Can we see that again? Number 1, this official receiver is a public employee. Solvency practitioner is independent person. Official receiver appointed by the judge. Solvency practitioner appointed by the debtor. Official receiver in liquidation. Insolvency practitioner in reorganization or IVA sometimes. Because reorganization and IVA are the same thing. They are the same thing. Official receiver would take the amount of money and would divide it between creditors. Insolvency practitioner, no, he does not pay anything. He makes the plan. He can be an accountant, good lawyer. He can make the plan, plan for the debtor, in which he would tell the judge and the creditors how we can pay them back in the future. We have once the debtor becomes a bankrupt. Once the debtor becomes a bankrupt. When that can be? When do you think the debtor becomes a bankrupt?
When the court made the order for the bankruptcy.
When the debtor becomes a bankrupt once we have bankruptcy order. Once we have bankruptcy order. From this date, from bankruptcy order, when it was made, the man or the lady who was a debtor before becomes a bankrupt. Decision was made by the court. Now we have some duties, and these can be questions, of course, true or false, and you can mention them, you can talk about them. Duties. If you become a bankrupt, what do you expect? What can you do? Someone becomes a bankrupt. What he or she can do? Even without looking, just think about it for a minute. A bankrupt can do something? Of course can do. Amal.
After he is bankrupted.
Yes, after and even before that. The duties.
The we said that the debtor it's become bankrupt and talk with he's a الترستي اللي هو insolvency practitioners.
Okay.
He can go again to the business.
Okay.
The bankrupt must provide an information to the official, to the official professor, to the official about the financial information about its.
Okay, that's one. Yeah.
If he has an assets, he can pay them and pay his.
Yes.
Like she said, all of the non-exempted assets must be handled to the court or
Yes.
to the trustee. And between the bankruptcy order and discharge, any money he made must be also handed to the trustee.
Summer?
The same, he must coordinate with the court and provide financial analysis for his.
Okay. So he has fully to cooperate with the court. The debtor who becomes bankrupt, he has to provide all what we have here in these points. Number one, he has to provide the official receiver, the trustee, all necessary information, financial affairs, within 21 days from the time he was asked. From the time when the trustee, when the official receiver asked the bankrupt to ask the debtor to provide information on financial aspects, he has to. If he cannot, if he does not cooperate, consequences will be harsh. He might be imprisoned. Maybe. Number two, the assets. He has to submit, the bankrupt has to submit all his assets, which is called non-exempted assets. House, land, car, money, machines, bank statements even have to be handed out.
Even if the assets were not related to the same company, he's.
No, not to, we're talking about the person. It doesn't matter if it's a company or a human being.
If he was bankrupt because this certain company and he has other companies, the assets of the other companies are handed to this person.
No, it's not like this. You did not understand the whole point from the beginning. Bankruptcy would be who can apply for bankruptcy? Any person. Can be a human being, can be a fictitious, like a company. Now, this person you talk about, he applied for bankruptcy, isn't it? Or you say that he has a different company, another company. Now, the first company, it's a partnership maybe. So he's got unlimited liability. Then you become a bankrupt. Then you have to pay everything you have. Anything, non-exempted money. But the second company you talk about, that company might be, like for example, limited liability, whatever company. It has its own name. That's a separate person. A company, it has its own name, identity. We cannot take the money of the second person. It's not. We are judging somebody. This person has lost. He's applying for bankruptcy. That company, it's not his own company. He might have some shares. He might have some shares. If he has some shares in a different company, then we can take his shares. We can sell them. But that company, it can be like, I cannot own a company myself unless if it's a limited liability company like we said in the States. And sole trader, in this case, we have no difference between the company and the person. We can take the money. But in a company like limited company or limited liability company or partnership, and he was not the only person, we can take his shares. We can sell them. Anything he owns, we can take. Any financial affairs, any financial information as well have to be submitted to the trustee. Now, once this has happened, and we have made a decision, bankruptcy order, even later on, during bankruptcy, this can be before we have a discharge. Before the bankrupt has a discharge, which is called, this is during bankruptcy, from the time we make the bankruptcy order until the time we have a discharge, this is still, it's a process of bankruptcy. Any extra money you make as a bankrupt should be declared to the trustee. Anything, then it means the bankrupt will be under surveillance, under inspection all the time. Any extra money you make, you have to hand it out to the trustee. In addition to this, number 4, in the UK, if the bankrupt makes any transaction over £250, he has to declare himself as a bankrupt. Like, declare to the second party. Like, if I want to go to buy something, I was bankrupt, and still, see, all what we're talking about is until we have a discharge. After we have discharge, it's a different life, a new start. You can be free. Number 4, as I said, he has to disclose bankrupt, disclosing himself as a bankrupt if the amount of money he wanted to invest or he wanted to use was more than £250. Now, in addition to this, if he has bank account, building society. In the UK, they have banks and they have building society. Building society, it means small banks. They have small financial institutes. They call them building society. It's a term, building society. If they have any account, these will be closed. The accounts will be closed. Payments here, he should not make any direct payment to any of the creditors. All payments, any extra money he makes before he has discharge, any extra money he gets, it has to be handed to the trustee, not to the creditors. He has to attend the court. Anytime he's being asked to attend the court, he has to attend the court. If he refuses, he will be arrested. He will be arrested. So it must be tough. I mean, looking at these points here, it must be tough for somebody like that. It's not something to enjoy. You know, everything will be closed down. Your business, you'll be handed out all financial information. You will not be free, even to travel. Sometimes people cannot travel. Sometimes they will not be able to leave the area they live in. Too many restrictions will be imposed upon bankrupt. In addition, we have some disadvantage. See, look at the disadvantages. They look like the same in some aspects. Disadvantage of bankruptcy. Number 1, Haneen.
Once the creditor has been made bankrupt, all assets belonging to him come under the control of the trustee.
It's nothing new, including his
home.
His home. These are, as you can see, disastrous long-term implications. For the long term, he will be poor. All of or the rest of his life, most likely, this bankrupt will be poor for the rest of his life. Most likely, because any money he makes, he will have to pay. And he will not be able to have the freedom to work in business anymore. Number 2, Jada.
Restrictions placed upon the bankrupt and the stigma of having to declare oneself as a bankrupt for a certain transaction.
It's a stigma. Once you declare, the name will be in the newspaper. The bankrupt's name will be in the newspaper. Everyone in the society would know that this place has been closed and this man or this lady is not working in business anymore because he or she becomes a bankrupt. It has a negative impact not only on him, even on his family, his children. They will not feel well about something like this. You know, people will look at them in a negative way. And even look in Europe, people will think, "What? It's fine, it's okay. You know, today we lose, maybe in the future we can make money." For them, it's something, it can be sometimes natural. But in our society, people will not accept it. Even if you have a decision by the court giving you the freedom and the discharge, you think people will forgive you? What do you think? Of course they will not. People here in our society, and even most likely in most third world countries, people, creditors, will not forgive. And they would keep asking. If they're not successful to get the money using the court system, they can go through traditional system. They can use the customs, traditional system. They keep asking. It's their own money. Anyway, this would leave a stigma of declaring somebody a bankrupt. His business will be immediately closed. In addition, loss of any assets of value, anything which is important for you. You might have the house which you lived in for 50 years. You might lose it. Something you like so much, like even losing here the pension, even the pension هو التقاعد. Even you might lose it. Life insurance, you might lose it. You might lose everything to pay the people who you're supposed to be from the beginning. And even here, losing an assets it may acquire during the bankruptcy, such as inheritance. You see, in this gap, in 2 years, 3 years, 5 years, before discharge, this bankrupted person inherited £1 million. His father passed away, and he inherited a good amount of money. This amount of money would be taken away from him and would be given to the trustee. But if this happened, inheritance after the discharge, it will become yours. It will become his own money. The same thing with insurance. Sometimes people get the money, insurance money, then you have to pay them to the trustee. I mean, nothing will be kept for that person. Bank account will be closed. Bank accounts will be closed here. In addition to all of these points, the status. What kind of a status? What do you mean by the status? Makana. His place among traders. His place in the market. He would lose it. He would lose it. In addition to the management, he cannot even manage a company. He cannot work for other people to manage. He can work, yes. The bankrupt can work, can be employed, but he will not be able to have a job in a management committee. He cannot be a manager. He cannot be in a senior position. Even he cannot be elected. He cannot run for the parliament. He cannot run for the local authority. See, too many restrictions. It's not easy. Lots of. Even the credit in the bank, he would lose it. He would lose it. Even if you want to have a new bank account, you can have. But this new bank account, if you have it, you have to inform the trustee that you have a new bank account and how much money you have in and how much money you have out of this bank account. It's too complicated. It's not easy for people to have bankruptcy. You want to say something?
The ones related to the parliament and local authority.
Parliament.
For his life or plus after?
No, it says here may not. It's not definite, but may not means if during the bankruptcy, of course he will not be able. After he has a discharge, then he has the freedom to run. But I think this would be easy for him. You think people would trust him to run for election? It's not. Do you have any alternatives? Any alternatives to bankruptcy? Any alternatives? Yes. See, bankruptcy is the worst situation. Bankruptcy is something is not acceptable by many people. But then we have to look for alternatives. One of them is called informal arrangement, in which the debtor and the creditors can sit down together, can talk about the case, can solve it by whatever means. As long as they have agreement, as long as they accept the solution between them, it's unofficial. The court does not interfere. No court, no trustee, nothing. It's only here, informal. It's unofficial. Between creditors and debtors, which is fine. Anyone can sit down with his own creditors and can solve the problem. The second, which is IVA, we had it before, but then we have to explain it in details now. IVA, individual voluntary arrangement. This can you, Amal?
This is a formal version of the previously described arrangement. Debtor would need to apply to the court with the help of an authorized insolvency practitioner. He or she would supervise the arrangement and pay the creditor in line with the accepted proposal. Okay, as you said before, that we have this arrangement can be made between the trustee, which is called insolvency practitioner, and the debtor. They can have the plan, and this plan as a proposal, it can include the following. It can include, of course, all the financial information in addition to proposal to the creditors. Can be based on offer. This offer would be based on 75% of the amount of money. If the debtor satisfies
creditors who own 75% of the whole amount of money, then in this case we have the final acceptance from the creditors, and we can take this proposal to the court to authenticate it, to accept it. Now, as you can see here, the value of the debt, 75% of the value of the debts. Not talking about 75% of the creditors, no. Even if you have 10 creditors, and only two of them, having the value of the debts of 75%, and in this case we have to satisfy them. They would have to accept whether monthly payment, weekly payment, on a specific dates, we have to pay them on a specific period of time. It can be 2 years, it can be 5 years. And in this plan, if they accept it, then we have to take it to the court to authorize it, to accept it, to give it the last finish, the last acceptance. And then from that, we can start regular payments. These payments have to be paid to the creditors, in which we can satisfy them until they have their own final payments have been fully paid by the sometimes in some cases what happens, even in the plan, the debtor can suggest that he cannot pay the whole amount of money. He can pay only 80%, or he can pay only 60%. I mean, everything can be based on this plan, and within this plan, with this proposal, whether you accept it or not, it's up to you. No one can force the creditors. It's up to them. It's their own decision to accept such a plan. And if we have the majority have accepted such a proposal, then the minority would have to accept it. Even if we have those minority who did not accept it, it's not up to them. The only way you can collect your money as a creditor, the only way would be IVA. Number 3, we have administration order. As I said, if the amount of money in debt was less than £5,000, which is little amount of money in this case, there is no point to have bankruptcy. It's not fair to have a bankruptcy. Then we have a decision made by the court in which payments have to be made by the debtor to the court, and the creditors would come to collect their own payments from the court until he pays the whole amount of money. It can be £1,000, it can be 4, it can be 5, until they have their own amount of money. In this case, in this situation here, no further actions can be taken. The only action is to pay. Debtor would have to pay the amount of money requested by the court, which can be up to £5,000, the maximum. And even this amount of money, 5 or 4, whatever, there is no interest. He or she, debtor, will not pay interest for it. No interest. And if there was some fees, this fees, the court fees, of course the court would have some fees to be paid. These fees would have to be added to the amount of money, in which the debtor would have to pay them in due time, on a regular basis. How long would it take to have a discharge? From bankruptcy order to discharge, how long would it take? How many years? Minimum can take 1 year. Minimum, as I said before, in the UK, minimum this can take 1 year. Sometimes this gap or this period of time can be extended up to 10 years. Maybe more, maybe less, based on the situations. Based on what, as we can see here, this discharge is not necessarily automatic. It's not automatic. It can take time. And this discharge can take 1, 2, 3, 4, 5 years. It can take a long time. And even sometimes, if people have a discharge, we have some exceptions. Like, can you read?
Exceptions?
Yes.
Exceptions include debts arising from fraud.
Yes. If there was a fraud, deceptions, we don't discharge that person.
Certain crimes and fines, certain other debts such as damages or personal injury or money owed under family proceedings will be relied on only if the court agrees.
Yes, in some cases, even if we have discharge for that person, there are some exceptions in which he or she will not be discharged, will not be free. They would have to pay that debts, especially if we have certain crimes committed, like talking about here, deception. He was concealing information, he was hiding money, then he would have to pay for this. in one of the cases here, it says that if we have the second bankruptcy, if this bankruptcy was not the first, was the second, and this person had bankruptcy in the past 15 years, and as you can see here, he will not be automatically discharged. It will take about 5 years, not 1 year. Here, this gap will be extended. Any money you make, you have to give it to the trustee. This gap will be extended. Even sometimes can be this gap or this period of time, it can be 8 years or 10 years. If he was committing crimes, if he was deceiving people, if he was lying to the court, if he was not cooperating, if the amount of money was too much, if you have many reasons in which the judge can decide to give this person a discharge or not. Again, this would lead us to the same question here I was mentioning, like if the same person bankrupt again before here, like here, we have bankruptcy and we have discharge. And after discharge, if you would like to come back to business, you can. You can have a new life, but you have some restrictions. You will not have the freedom. But once you can apply here, you can apply to the court to have permission to come back to work, to business, you can do so. This can be after 1 year, after 10, after 15. It depends on the judge who can evaluate the whole case. He can evaluate it, in which here we can understand that the same person who has bankruptcy in the past, now he's doing business again for the second time. He's doing business. In this case here, he can become a bankrupt. The problem we face with here, that he did not have a discharge yet, and he went for business without telling the trustee, and he becomes a bankrupt for the second time. Now the consequences will be harsh. He might not be discharged in the future, and he might be imprisoned. He might be imprisoned. We have serious consequences. The last slide we have is, which is really important, can bankruptcy be reversed? Can we cancel bankruptcy? Once we have a decision was made, we're still here. After the decision was made, we said we have stigma, bad stigma on that person. We have harsh consequences. You might lose everything. But can we cancel it? Yes. Or not? Can we cancel bankruptcy?
Yes.
Can we reverse? Yes. How? We have 3 ways. How can we cancel it?
The bankrupt person can apply to the court to reverse this bankruptcy order.
Okay, on what basis? In what basis?
If the debtor pay all the amount of the debt and
Yes.
give guarantees.
Okay, number one, if there was a mistake in the procedures, if there was a mistake, there were steps were taken, and those steps were not supposed to be taken from the beginning. Here, these proper steps were not taken, but there were different steps were taken by the court. In this case, we have to reverse the bankruptcy order. We have to stop it. We have to cancel it. There was a mistake in the procedures. Number 2, if the bankrupt has paid the full amount of money, I was like, somebody give me the money to pay. What can I do? I can take the money, hand it to the trustee. He would pay the whole amount of money to the creditors, in which we can cancel the bankruptcy. There is no bankruptcy. Or at least we can guarantee here, paid in full the amount of money, or can guarantee, satisfy to the satisfaction of the court. Can agree here to satisfaction of the court that the bankrupt would pay the whole amount of money. We can cancel the bankruptcy decision, and we can move to something which is called IVA, which is here. In IVA, even we said IVA has to be done before we have bankruptcy order. Usually IVA is a step, it's a preventive step. Preventive, وقائية. This IVA, individual voluntary arrangement, like a reorganization, it has to be taken before bankruptcy order is made. Because we have to survive insolvency. But sometimes it just happens. decision was made by the judge, bankruptcy order in 2002. After 6 months, the debtor came and the bankrupt came and said, well, I'm going to pay the amount of money. I have some guarantees. I have some sponsors, but give me some time. Then we can apply IV. This can be expensive, can be difficult, can take more time because it's made after the bankruptcy order. Because it can be so complicated because the money already, we have taken the money from him and we divide it between many people, many creditors. Now we have to look again at the same equation, how much money we paid, how can we pay back, how can we guarantees. I mean, we can do, in all 3 cases, we can cancel bankruptcy, in which we can come back to business, can hold the assets and can pay the whole amount of money for the creditors. Thank you very much for your time. Thank you, and I will see you Sunday, inshallah.
Hello everybody, I want to talk mortgage business. Mortgage contract is contract right to arrange my eyes on something security for debt and trade law, known as commercial mortgage contract as contract right to arrange security for debt moved business. This means that there is commercial mortgage on property that must be movable, and that should always find that there is real estate finance and intended to buy property with access to the path of the money to pay the loan, and the loan is secured by the property. This contract is commercial by private institution, but the most important of which is not just the idea of paying real estate loan secured by the property itself, but is linked to securities and remain the company is the creditor sells the debts of individuals. Transferee may be material or moral, but at least that was the moral requirement to be constant as a negotiable instrument. So they can reply to him that the mortgage business is determined by commercial mortgage business pledged debt for the debtor when is a commercial mortgage for the debtor. Then commercial mortgage is the creation of commercial debt. Then when there was a commercial debt and mortgage debt decide to be a commercial mortgage without standing on something else. Of the mortgage contract continued because it cannot work as subject independent. They must be determined to ensure that the religion for original features. General of the mortgage business is his business, and his place is the mortgage contract, the text of the civil code, that for the limbs are the 2 parts. Mortgage, the owner of thing mortgaged. The mortgager of loaned funds, it was decided to foreclosure in order to ensure these funds have located to other people. According to the text of law, and they aren't parts to the mortgage contract, it may be the debtor's person, it may be to the debt's person and another person present, and we also find that the mortgagee may come the holder of thing may present another person may have the person. How the contract is concluded. Mortgage contract signed concluded positively, and acceptance doesn't need to write, is not to prove or to protest in the face of other. There is an exception to that in respect of rights arising from the instrument, when will the instrument promissory note or the other instrument of that to be endorsement and as formality. And before there is no contract pending conclusion of the contract, when the contract fixed in the instrument to be form of an endorsement in the case of instrument, but if may name has to be and transfer and take action, which often is stable in the books of the issued instrument, are subject are subject to the inalienable rights instruments in nominal receivables and record in the books of issued instruments. What is the impact of the mortgage? The resulting mortgage possessory two rights. One, right in solitary thing. B, right of proprietary in obtaining the loan amount and recovery of the price of the mortgaged, and legislature with regard to these two effects said they don't exercise their in face of third parties unless the transfer of possession actually go to the mortgagee. And not only so, but still the thing mortgaged in possession of the mortgagor, the length of the mortgage on the transfer of possession. Possession, the creditor and mortgage is the number of images. One, jump actual possession and but the legislature requirements of the creditor mortgage or just take in possession of the thing mortgaged to put at his disposal to how with other on the belief that the thing has become in the custody or delivery of legal a delivery of legal. A delivery person instrument entitled to take delivery of the thing. Legislator said to extract the person instrument is the thing mortgaged and gives the holder the exclusive right of the receiving. This is transfer of possession. If the fair thing to damage or loss, it is the fair thing of damaging or less. It is the creditor's right to ask the judge to sell it, and as the thing will enter into possession of the creditor and store on his shoulder several obligations. One, the mortgagor shall hand over the debtor's receipt stating the thing mortgage of the type, its description and its value. Two, it's committed to maintaining the mortgage. A thing was needed for regular maintenance by the obligation to carry out the maintenance and preservation.
Okay, we are going to talk about legal aspect of e-commerce. Before that, we are going to ask one question, that is an internet contract enforceable? In our practice, we frequently receive a question about the enforceability of so-called internet contracts, agreements reached between practice over the internet, generally speaking, an analysis of the enforceability of any contract in the same, whether the contract was formed by the parties over the internet or by the execution of written documents. The legal aspect of e-commerce, a basic guide to e-commerce, a guide to doing business over the internet or web, includes basics, getting a computer connected to the internet and developing a web page, understanding electronic data interchange, building and managing a virtual team, product development, developing your online store, online transaction, etc., online marketing and monitoring your websites and other general resources. The second, e-commerce and the law. And e-commerce guide covers e-commerce regulation, tips of complying with the e-commerce regulation applying to telephone and fax marketing, privacy and electronic communication regulation, tips of complying with the privacy and electronic communication regulation, e-commerce and the data protection at 1998, distance selling regulation and provision of services regulation. E-commerce and tax law journal, a legal publication created and published by the Internet Business Law Services, ILBS, the world's largest interest law publisher and Thomas Jefferson School of Law Masters in Law program. The law journal published writing by academics, practitioners and policy makers on a variety of topics, including e-commerce, electronic contracting, techno-torts, cybercrime, privacy, internet taxation, international taxation, and etc. The Electronic Commerce Law Subcommittee, the American Bar Association Electronic Commerce Subcommittee developed and recommend efficient, flexible, and equitable policies, principles, and practices for business to business and business to customer electronic commerce. It's actively engaged in project directly and through 3 working groups: the customer protection working group, the working group on transferability of electronic assets, and the electronic contracting practice working group. Online advertising and marketing, the Federal Trade Commission, FTC, is the primary federal agency regulating e-commerce activities, including use of the commercial emails, online advertising, and customer privacy. This page provides information and links to legal resources, which include case highlight, reports and work hopes, laws, rules, and guide, and compliance documents. Electronic commerce, the United Nations Commission on International Trade Law was established by the General Assembly in 1966 to further the progressive harmonization and unification of the law international trade. The Commission has since come to be the core legal body of the United Nations system in the field of international trade law.